4 cases this morning. We'll take them in the order that they appear. We'll take a 15-minute break between the second and third case and invite everyone to have coffee with us in the Commons during that 15-minute break. Mr. Efferman, are you ready on the first case?
Yes, Your Honor. May it please the Court, Michael Efferman, on behalf of the appellate, Stephen Bowman, I'd like to reserve 5 minutes of my time for rebuttal. I'll focus my time this morning on the first issue raised in the briefs, and that is whether Mr. Bowman's alleged violation of the sheriff work camp was willful. As I've explained in my briefs, the state has not proven, by a greater weight of the evidence, that Mr. Bowman willfully failed to complete the sheriff work camp. Notably, on page 4 of its answer brief, the state concedes that the record does not establish a willful violation. In the brief, the state argues that Mr. Bowman, and this is quoting, cannot excuse his failure to comply with work camp rules, even if that failure might not be deemed willful. Well, of course, to violate a defendant, or to prove that a defendant has violated probation, the state must establish that the violation is both substantial and willful. If Mr. Bowman's alleged violation was not willful, then the trial court's order must be reversed. Mr. Bowman was placed on probation in order to either spend 28 days in jail or complete 28 days of the sheriff work camp. But when Mr. Bowman initially met with his probation officer, of course, he wasn't given that option. He was told he had to complete the days on the work camp. That was in December of 2005, and over the next 5 months, Mr. Bowman completed 16 of the 28 days. Due to illness, he missed 6 scheduled appointments. But the record is clear that Mr. Bowman was, in fact, sick on each of the days that he missed. And probably more importantly, the record is clear that Mr. Bowman reported to the work camp within 24 hours and explained the reason for his absence and rescheduled the appointment. Now,
what about the judge's findings where he found that there's no showing that this person was incapable of performing that work? He may have put it in a note, but may be uncomfortable. He may not be in the best of health. I don't know, but I'm going to find it was a willful and substantial violation.
I think, A, that's not supported by the record. That's on page 70 of the violation of probation hearing transcript. The state didn't present anything to prove what the judge found. But Mr. Bowman specifically testified that when he was sick, he could not go to work. That's on page 47 of the transcript. And he said that he explained some of his condition, or the symptoms that he had. One of them, of course, being an upset stomach. That's on page 50. And he said because of the upset stomach, he couldn't go to the work camp. Without getting graphic or detailed, of course, you can understand a situation where someone, because of an upset stomach, may not be able to report to work. It happens to all of us every single day throughout the year. People are unable to report to work because of sickness or because of illness. So the state didn't present any evidence to refute that. There was evidence that Mr. Bowman went to a doctor's office. The state didn't put on the testimony of a doctor who said, I examined Mr. Bowman and he was malingering, or I didn't find any symptoms that would have prevented him from going to work. So the only evidence in this record is that Mr. Bowman was in fact sick and that he was unable to attend those 6 work program days.
At some point, does the frequency of the absences go to show that maybe they weren't all legitimate?
I don't know the answer to that question. I think part of that depends on what are the program rules that are in place. I think if you look at the circumstances of this case, we have a period of 5 months and he's completed 16 days. He's missed 6, or roughly on average 1 a month. Certainly you can't say that he's not attempting to complete these days. He's completed over half of the days. I think it's also important, again, to look at the program rules. Sergeant Lee was the program supervisor, and he explained that the rules of the work camp provided that if a defendant fails to report for a scheduled day, the defendant must report to the work camp on the following day between the hours of 8 a.m. and 4 p.m. Most importantly, on page 34 of the transcript, Sergeant Lee stated, and I quote, he missed the scheduled work days, but he did report and follow our guidelines as far as reporting to the work camp office to reschedule his missed days. Pursuant to Sergeant Lee's testimony, Mr. Bowman complied with the work camp rules. He did not willfully violate those rules. He followed the rules. When he was sick and he couldn't come on the day that he was scheduled to appear, he immediately reported, explained that he was sick, and rescheduled the day. But again, the other thing to consider is just because someone is dismissed from a work camp, it doesn't mean that that dismissal is willful. especially if the work camp doesn't have objective criteria for determining whether or not the dismissal is willful. And I submit that in this case, based on the testimony provided by the state, there is nothing establishing that the work camp rules contain any type of objective criteria for determining whether or not the dismissal is willful. Sergeant Lee stated on page 28 that Mr. Bowman could have been violated after 2 absences. He stated on page 29 that the program is, quote, a little lenient when it comes to someone who's in doctor's care. But then on page 30 and then...
He was told he was going to be dismissed from the program if he didn't show up that last time, and then he did not show up the very next day.
He was told that he couldn't have any more absences, but again, if he's sick, that's the key to this. And that's what Sergeant Lee said on page 30 and 36. He said that if a defendant misses a certain amount of days, even if sick and regardless of the excuse, the defendant is terminated from the camp. So the camp has a policy that doesn't matter what your excuse is. Doesn't matter.
Told me they had to have an objective policy, though. I mean, that was their policy.
Their policy was you get dismissed regardless of your excuse. You could have a justification that would have meant you couldn't come.
But you're saying that he could be dismissed for some reason that would not amount to a willful and substantial violation of probation.
Exactly, Your Honor.
Because it would be some violation of a rule which perhaps is beyond your control.
Exactly.
But then what would the trial judge be required to do? Say, okay, you do the 30 days instead? Or?
In this case, without question, in light of the fact that he was originally given the option, I think, yes, he would have had the option to do the remaining 12 days in jail. And in another case, I think the court would have to consider the factors, determine if there is a reason that this defendant can't complete the work program, maybe give him some other alternative.
According to your argument, a work camp could just simply say, listen, we're through dealing with you, pal. You're too much trouble. I don't care if you're really sick or not. I mean, we're busy. We can't deal with, every day doing makeups and stuff like that. And so you could have a situation where the guy gets kicked out, but it's not a violation.
No question. I mean, I think that's Sergeant Lee's testimony, page 30 and 36. Even if you're sick, regardless of the excuse, you're out if you have too many days. So, of course, you can imagine someone who breaks their leg. The work camp can't allow someone who has a broken leg can't complete the work camp days. He may have missed several days because of the broken leg. Pursuant to Sergeant Lee's testimony on 30 and 36, that person would be dismissed. There's no way any court would find that someone with a broken leg has willfully violated probation.
Couldn't that be prima facie evidence, and then the court basically saying, okay, you were told there are excessive absences. If you really couldn't be there, then it's your burden at that point to come forward with some testimony showing you really could not work.
But he did that. Again, I mean, I think it would be different if he didn't show up every single day, the following day, and comply with the rule. I mean, if he signed up for a day, failed to show up the next day, then now he's willfully violated because the camp rules require him to show up the following day, explain the reason for his absence, and reschedule the day. The record is clear, unrefuted. He did that for every absence.
If he did that, what was Sergeant Lee's version then of the reason for kicking him out of the camp?
Too many absences. Doesn't matter.
But apparently, according to the camp rules, he was permitted to report the next day when he was not.
Exactly. We don't know from these camp rules.
What does, I mean, I suspect that Mr. McCoy has a different view of this, but what was Sergeant Lee's position? You seem to be telling us that Sergeant Lee said he followed all the rules and nevertheless kicked him out of the program.
Yes, because I think Sergeant Lee took a position that at some point, regardless of he said it, again, page 30 and 36, even if sick and regardless of the excuse, after a certain number of absences, and we don't know what that number is. The rules don't say it's 2, 5, 7. He says we're a little lenient. After 2, I could have kicked him out. We don't really have objective criteria even from that regard. But we know that Sergeant Lee kicked him out because of excessive absences, regardless of whether or not he had an excuse for those absences, even though he complied with the guidelines and reported within 24 hours for every single absence. The state in the answer brief acknowledges that the camp policy requires dismissal, quote, regardless of cause. That's on page 5 of the answer brief. The state concedes that if you have excessive absences, it doesn't matter what the reason is. You're dismissed from the camp. You may be dismissed from the camp. It doesn't mean it's a willful violation. I think defense counsel below relied upon the example that we can imagine an employee that because of illness is required to miss several days of work. And at some point the company may be required to fire that employee because of the excessive absences. It doesn't mean...
You're down to about 5 minutes, and I'd like you 5 minutes, a little over 5 minutes. I'd like you to talk a little bit about this 30-day in jail option not being available to your client.
My position is that he was sentenced in July of 2006, and at some point he was told, and the trial court acknowledged during the VOP hearing, that that he had the option to either do 28 days in jail or 28 days in the work camp, acknowledged that the record's clear that he wasn't given that option. He completed 16 days, so he has 12 days to do. And at this point, he's now done a year and a half in prison. He's easily complied or completed those remaining 12 days. And so I submit that, again,
Mr. McCoy says in his brief that there's no evidence that he ever chose to exercise the option.
I think that's wrong, again, when you look at the record. Mr. Bowman said that he reported to probation immediately after he was given this original sentence. And he said that initial probation officer that he reported to told him, you don't have that option. You have to do the days on the work camp. The state didn't present testimony from that officer that he reported to. The probation officer that they did present acknowledged that it was possible that Mr. Bowman saw someone prior to coming to his office. So there's nothing in the record to refute Mr. Bowman's claim, number one. But the record is also clear that that Mr. Bowman did have that option. But I think for whatever reason, and I think we can understand the reason for the uncertainty or the ambiguity, because the judgment didn't say anything about 30 days jail or 30 days work camp. The judgment only said work camp. But yet the plea agreement clearly said jail or work camp. So, again, my position is I don't think it's willful. But even if you find that it's willful, the most he should be doing is 12 days, and he's now done a year and a half. Okay. And then quickly on the third point, I won't spend much time on it. Obviously, there is an error on the initial score sheet. This court's precedent in Fitska says that you can't raise that error in a VOP proceeding. That's in conflict with the second district's position in Stubbs that you can raise an error on a score sheet during the VOP proceeding. Again, I'm hopeful you'll never reach that issue, and you'll agree with me that the violation wasn't willful. But if you do reach that issue, I would ask the court to certify the conflict with Stubbs. I'll reserve the rest of my time for rebuttal.
Good morning, Your Honors. Please, the court, Charlie McCoy on behalf of the state. Your Honors, turning to this first issue, the state completely disagrees with their reading of the record, and we haven't conceded away the willfulness of the violation, or maybe stated another way, the trial court didn't abuse its discretion by finding a willful and substantial violation. Now, I want to go back to the original plea hearing because there's something in there that maybe hasn't gotten as much emphasis as it should have. But when he was originally entered his plea, he was actually told two things. First, and this was Judge Decker. Keep in mind that Judge Decker presided over the initial plea, and then Judge Hawks over the probation hearing. The judge told him first that 40 months was going to be the suspended sentence, and that if you willfully and substantially violate probation, that would be the appropriate sentence. So he was on notice that a willful and substantial violation could result in being returned to prison. Now, whether the 40 months was correct or not really is immaterial at that point. But then he was told later, and this is where I think we do agree that the judge verbally told him he initially at least had the choice of 30 days jail, work camp, 30 days jail, and then she said, or whatever is left of the sheriff's work camp days. But right before saying that, the judge said, if you don't sign up, and remember he was told to sign up within 30 days, and you don't qualify for any reason, even though it's no fault of your own, the punishment for this is 30 days in jail. So he accepted that as part of doing work camp in an alternative of going to jail. So he was unaware of two different levels of sanctions, if you will. If he was completely without fault, but still for whatever reason couldn't do the work camp. And now the work camp's not unreasonable in saying that somebody who has excessive absences has to be terminated. They've got to count on a flow of workers coming through there and not
Let me look at the 30 days for a second. Are you arguing, let's say he did 15 days of the work camp.
I'm sorry, Your Honor.
Let's say he did 15 days of the work camp.
Yes, sir.
Is it your position that he could not at that point say, I want to do the additional 15 days in jail under what the judge told him?
Under what the judge told him, it seems to me that he could have. He didn't do anything at that point.
Okay, if he could have, then I'm having more problem with 30 days than I have with the medical, but I don't know how the other judges feel. But it seems to me that if somebody is told as part of their plea, you can do the work camp, but if you can't do that, you can finish it up in jail, then they try to exercise that option. And his testimony is he went to the probation officer. Shouldn't the state be bound by that plea agreement? And can that be a willful violation when he tried to comply with what he was told by the judge?
Well, yes, Your Honor. The Judge Hawks found that he really didn't try hard enough once there was obvious confusion about what his options were. Secondly, the factual basis for...
I mean, if a probationer goes to his probation officer, I know that's, his testimony, but let's assume it's correct. What else does he have to do? I mean, if the probation officer tells him, that's not an option, where does someone go to? I mean, this is your probation officer. Who else in the system are you supposed to be speaking to?
Well, I see pro se letters to courts. I see pro se letters to state attorneys. I see pro se letters to the public defender that get in the file all the time. And he could certainly have contacted the public defender's office. The problem was, of course, that the written documentation of what the judge said verbally was incomplete, and at the bottom of the judgment, where there's the special comments on the last page, it said, sign up for work camp within 30 days. There wasn't any dispute that he initially had the choice. Where the dispute comes from is what happens if he didn't complete the work camp. And the factual basis, though, which I think also rises to a willful and substantial violation, is really found at pages 25 through 31 of the VOP hearing transcript, the violation of probation transcript. And Mr. Lee, who was a sergeant in charge of the work camp, a supervisor, went through his absences. And we all agree that he missed 6 days, and with the sixth missed day, he was terminated from the work camp program. But he came in, the first day he missed was in January of 06, and there was no documentation as to why he missed it. He may have claimed he was sick. He did fill out an excuse after he got there. Then he misses in early February, the second absence. He comes in the next day. He didn't have a doctor's note saying he was under medical care, but he had a card saying...
Didn't the lawyer say, wasn't there a problem going on here about the lawyer thought she was going to be conflicted out? And so she proffered she said she wanted to put in the written documentation from the doctors, but she was not allowed to do so because it would have to have been an after-filed exhibit.
Well, Your Honor, there's two problems I have with that. First off, that particular attorney knew for 3 to 4 weeks before the hearing she was assigned the case. If you look at the progress docket, there's no motion to withdraw, no motion for appointment of conflict counsel, nothing. She just assumed that since I've got a colleague, that's a conflict. We'll have to appoint a conflict attorney and it'll have to be continued. I don't think that's a reasonable assumption under the circumstances. There's nothing to prevent that motion. Secondly, I don't see where the conflict arises if you call a colleague. You're not vouching for him any more than any other witness. It's not a jury proceeding. And the colleague was going to testify favorably to the client, saying, yeah, I told him that he had the choice. And and as far as the documentation goes, what's critical is what did he tell the work camp at the time? If he didn't come in with an excuse, as far as they were concerned, it was an unexcused absence. And Mr. Lee did say that he cut the guy a break, that he could have been violated after 2 misses. Remember, the first one, there was no documentation from a doctor. He just came in and filled out a written excuse after the fact. The second miss was because he came in with a card saying he'd been to a doctor's office but couldn't get in. But then the state agreed that two of the missed and rescheduled days, for which he was still not terminated, he did have a medical excuse. Or maybe, 3 days he did have medical excuse, that he was under medical care. The last day in which he was terminated, the record doesn't say. They just said when he missed that day in late May, we terminated him from the program. So what you had was someone who had 3 out of his 6 absences actual medical care excuses, which were accepted, and he was given a last chance. And then 2 of them, and then another one he had a card, but not that he was under any particular care, and the 2 of them were really unexplained.
Well, but they were all accepted by the program, right? All 5.
Well, the first 5 were, and then when he missed the 6th time, they said that's enough. Now, they also said under their policies that they could have terminated him before they did. They kept trying to give him a break. And at some point, I think that's what persuaded the probation hearing judge that this had rose into a willful and substantial violation, that he missed 6 days over the course of, from early to mid-January until late May, so 5.5 months. They allowed him to reschedule until he got to the last one. The so-called documentation, well, it was accepted at the hearing without dispute that he had a medical excuse for 3, and a card saying he'd been to a doctor's office for a 4th, but 2 were unexplained, other than his filling out a form after he got there.
Now you say that was accepted without dispute, but didn't the judge who revoked probation say, I don't think you could merely show up the next day with some kind of note.
Well, I think he was referring to I think he was referring there to the first time when he had no documentation from a doctor and filled out an excuse. But nevertheless, Mr. Lease, he said we accepted the times that he showed up with the, in fact, from the way I read Mr. Lee's testimony, they accepted the doctor's appointment card as a sufficient reason for the second absence, and then they accepted both medical documentation for the 2 absences in April.
Right. Mr. Lee accepted all 5.
Well, he did, Your Honor, but I mean, he said I was trying to cut the guy some slack. We tried to give him a break. I could have terminated him sooner than I did. So I don't see. Never.
So sort of the man on the ground didn't see a defiant participant, didn't see a willful and substantial violation. He just, as has been said, there was just sort of an administrative problem with this man who apparently has medical problems, not being reliable in terms of showing up and going to work.
Well, what his testimony was, he quit drinking, and the withdrawal symptoms of quit drinking kept him from showing up, and that made him sicker than he'd ever been in his life. So I don't know.
I think that happens to some people.
I'm not arguing with you, Your Honor, but he certainly could have done a lot more than he did to document that, and it was happening repeatedly. The fact that, I guess no good deed goes unpunished here. If they'd gone ahead and terminated him right away after 1 or 2 absences, we'd say, look, it was troublesome enough for the work camp to not give him a second, third, and fourth chance, or fifth chance. But nevertheless, the fact that out of pure leniency, the work camp was willing to not enforce their excessive absent policies as strictly as Mr. Lee said they could have, does not have any bearing on whether a judge listening to a hearing on whether probation doesn't altogether rise to a willful and substantial violation. He accepted the condition at the original plea hearing that if he didn't finish the 30 days for any reason, he'd have to finish the remainder in jail. So he knew that he had no excuse, and that's what I was referring to when I said he
had been told twice, right, by the people who had authority over him that he did not have that jail option.
Right, but I'm saying before all that happened, the judge had already told him that if you don't finish the work camp, regardless of the reason, you're going to have to go back to jail. And we do agree that that's what he was told by the judge. There was a mistake because the documentation was incomplete. But the point is, before he even got to that point,
he got credit for 2 days, right, against the 30.
He had 28
He
to
did
do.
16 days, so he had 12 remaining.
Right.
So is there some reason to believe that if he had known he could have gone to jail for 12 days, he would not have chosen that instead of 40 months at DOC?
Well, yeah, if you put it that way, of course somebody would rather go to county jail for 12 days than go to 40 months jail in DOC.
Well, isn't that kind of what happened here, just a snafu, and the original scheme was not honored by the people who were supposed to implement it?
No, Your Honor, I'd like to respectfully disagree with that to some extent because he chose the option of work camp. I think it's undisputed if he reported to jail before ever going to work camp, he could have served his 30 days so they'd at least gotten it straightened out.
I asked you when you started, could he at any time discontinue his work camp and go to jail based on everybody's understanding at the beginning? And you told me your answer was yes.
Right.
Are you changing that answer now?
Didn't think so, Your Honor. No, what I'm saying is that I didn't intentionally do it if it sounds that way.
Well, you were just you started telling Judge Benton, well, he could have done it at the beginning. But when I asked you earlier, you said he could have done it any time in the process.
Well, certainly, Your Honor, we all agree that if he'd have chosen to go straight to jail, do not pass work camp, go straight to jail, he could have served his 30 days, or at least at that point, if the people in the jail said, no, you've got to go to work camp, it would have gotten straightened out. He chose to go to work camp to attempt to do the 30-day equivalent at the outset. The judge told him, you do the 30 days in work camp, and but for any reason you don't, you're going to finish the remainder in jail. We all agree that's what the plea hearing says on its face. But before he even got to that point.
So even if you win on the substantial violation by not completing the work camp, why isn't the remedy him just going back to jail for 12 days under the plea agreement?
Because to get to that point, Your Honor, you'd have to decide that the total facts of why he didn't complete the work camp did not rise to substantial and willful violation. If you agree, and the state's position is the court did not abuse its discretion, finding the total circumstances why he didn't complete the work camp to be a substantial and willful violation. At that point, the court could revoke probation altogether. And the facts were that he not only missed 6 times, but I say at least 2 and maybe 3 were not explained by medical documentation.
But now, just back to that point briefly, is it not the case that his lawyer said, I thought I was going to be conflicted out? May I get that documentation together and file it as an exhibit for the court to consider before you rule? Wasn't that proper denied?
That was denied. The problem I have with that, of course, is that there was no reason for counsel to have waited until the day of the hearing to bring all that up. There was no reason for him not to move to have appointment of a conflict attorney. And the time it took to get a conflict attorney on board and reschedule the hearing, there had been plenty of time to assemble that documentation. Now, the proffer wasn't very specific. And then I also want to emphasize, Your Honors, that what was critical, too, is what did he show.
In light of all the circumstances, though, wasn't it here really essential to know, because part of my frustration here is he had a doctor's note. We don't know what that doctor's note involved. Wouldn't it be essential to know if the doctor said he really couldn't work those days?
Well, I know that at least one of the times the doctor's note said he's released to work camp without further treatment beginning the day after the date on the note. I don't remember if there's any
It doesn't address the day after the note. It doesn't address the days that he actually missed, does it? So we don't really know what those doctor's excuses were, or whether the doctor really properly thought that he did not have the ability to work.
Well, the one I think I'm referring to is if I recall correctly, was he was supposed to work on May 17th. He shows up the next business day, which is May 18th, with the note from the doctor. The doctor said he could start, anytime beginning May 19th, the next day. He was released to work camp without any medical restrictions. That was accepted by both the camp, and that explanation, which I think came from Mr. Lee, was accepted by the court as well. I think where the court had its main problem was, of course, there were 2, and I know I'm over my time, but if I could finish.
You finish your answer.
That must be very near the end of the period he spent in the work camp, right? Maybe that was the very last excuse.
That was the next to last. That was the last one that was accepted, and then when he didn't report on May 31st, they just terminated him from the program, and they didn't get any more testimony from Mr. Lee as to whether he tried to give him a doctor's note or not. The record's silent on that one. That's just why I say, though, at least 2 were unexplained and maybe a 3rd one. And the combination of the unexplained absences and his failure to do more than he did to find out what his options were once there was some obvious confusion was why Judge Hawks found it rose to a willful and substantial violation of revoked probation. And we would say that's not the court didn't abuse its discretion in doing so, and ask you all to affirm that.
Thank you.
Did you want me to address that 3rd issue about
I know my time's
up. Okay, thank you.
May it please the court, I think I'd like to briefly address or respond to 3 arguments. First, Judge Wolf, you mentioned, and it was on page 41, that Mr. Bowman said, he testified, that he reported to the probation office and talked about the options that he had, and the probation officer told him, you don't have any options. You must do your days in the work camp. The state didn't present any testimony to refute Mr. Bowman's testimony that he reported to the probation officer, and the probation officer said, no, you don't have an option. So I submit that if he couldn't complete the work camp in this case...
That's verified by the paperwork we have here.
And if he couldn't complete the work camp, the proper, whether willful or not willful, either way, the proper sentence should be 12 days in jail. He's now served a year and a half.
That's the second person who told him that, right?
I think that's right. I think that this was the first person he reported to, and then he went to the assigned. I think the way that works is he's in court, he has to report to the probation office, he does that, that person tells him you don't have any options, you've got to sign up for the work camp, and then they tell him who a specific probation officer is going to be, and then he reported to that probation officer.
Well, what is this thing out on the Bluntstown Highway somewhere?
That's exactly what I'm referring to. So the first person he reported to was Bluntstown Highway. It's that person that Mr. Bowman testified, said he reported to that person, said that I have this option, and that person said, no, you don't have any option. You have to sign up for the work camp. So, and again, that's not refuted by the state. They don't present any testimony. They don't present that probation officer to say, no, that's not what I told him. I told him he had an option. So I think the record is clear. He was told he didn't have an option. He had to sign up for the work camp. So the sentence should be 12 days in jail. Referring to why the judge violated him, again, on page 70, and I'm quoting from the court, there is no testimony that he did not show up prior to 7 a.m. on each of the days he was required to show up. The trial court isn't even taking into account the fact that the camp did have a policy that allowed him to have absences, that allowed him to show up within 24 hours and explain those absences. It doesn't sound like the trial court accepted any of the absences as being valid. The trial court, pursuant to this statement on page 70, said the reason he's being violated is because he failed to show up at 7 a.m. on each of the days.
Let me ask you this, and somewhere in the course of the revocation hearing, it sounded like, it looked, if I remember correctly, the assistant state attorney said something like, well, if that's what at that time, they did not have the sentencing transcript.
That's right.
So it was not entirely clear what had occurred before Judge Decker.
That's right.
And the assistant state attorney said something like, well, if he has the jail option, we will honor that.
We feel bound by that. That's exactly what he said. There is this confusion. There's this confusion apparently with the probation office. There's a confusion with the court. There's a confusion even with the defense attorney not having the transcript going in and saying, I know the previous attorney told me this was the option. I'm not sure it's in the paperwork. They find out by the end of the hearing that it was actually on the plea agreement. The state attorney didn't realize that. And again, somewhat related to that regarding the documentation, I can understand this defense attorney's position. She's called opposing counsel and explained what her concern is regarding the conflict, and opposing counsel says, I don't object to you getting off the case. I don't object to us continuing this case. So she's thinking this hearing is not going to occur. She shows up because it's unopposed, and it's very rare that when a situation like that is unopposed, that a court would force the parties to go forward. So she shows up, the state says we agree, we would feel bound by this agreement. If that's true, we need to look into this further, and we need to allow her to conflict off. And then the court says, no, I want you to go forward today. And at that point, the state starts changing its tune and starts agreeing with the court. So I submit that at this point, she did say, in light of my concern, whether you think it's reasonable or not, please let me proffer the documentation. And at the very least, it was an abuse of discretion when the judge didn't allow the defense attorney to proffer the medical documentation. For all these reasons, I would ask that you reverse. Thank you.